Hello class and welcome back. This is the second video for Cyberlaw class, and in general what I'm going to talk about here is the difference between the Constitution, the statutes, and how to read cases, which are just three things that I think are incredibly important, obviously, for class. And in general, what I'd like you to do is go to your resources section of Campus Web and pull up the privacy handout that's in the week 1 folder, because that's going to be the main thing that I'm going to be talking about here and what I'm going to be working with, right? So now, what we're going to be talking about here is the idea of privacy. It's just sort of a background in regard to what is the whole point of what the lecture is, right? So privacy is a big thing, especially in regard to cyber law, because we now, right, I would argue are less protective of our privacy than we've ever been, right? I always make this analogy where, what would you rather me do? Would you rather have me, someone you may know or maybe have never met, be allowed in your house for 15 minutes or allowed to look on your phone unlocked anywhere I wanted for 15 minutes? Now, I know what my answer to that would be, right? But the idea in general is that, like, we don't protect privacy in the way that we used to. We try to, and we talk about it in a way of like, well, we don't want cyber criminals attacking your privacy. But the main issue when we talk about the law and the Constitution is mostly in regard to the government, right? So the Constitution in general stands for the proposition that the point of the Constitution is to protect citizens from government overreaching, right? Like, you think about every amendment of the Constitution. The First Amendment says that you're not allowed to get punished for free speech. Now, that's a big distinction that I always think kind of gets confused with popular media. The idea in general is the First Amendment doesn't say you're allowed to say whatever you want. It just says the government can't punish you for whatever you want. So if we had class and you were just screaming expletives the entire class period, I'm allowed to punish you because that's not a First Amendment right you have. I'm not a government actor. So the essential idea here is, what does the Constitution protect in regard to privacy? What does the legislative protect when it comes to privacy? And how do cases do it just the same? Now, in general, the Constitution is often defined as the supreme law of the land. Now, what that means is the Constitution can never be contradicted unless it's overturned or amended, right? And the Constitution has been amended, I believe, 17 times in the last 300 some odd years. So it shows you the fact that these are very fixed rules that haven't been changed for a really long time. In general, that means that every state actor, whether or not it's the legislative, people passing laws, whether or not it's the police, whether or not it's anybody, cannot violate your constitutional rights. They are above all else, right? Now, the way that your constitutional rights are protected are by a concept called judicial review, which is the Supreme Court's sole authority to evaluate the constitutionality of statutes. When you think about the Supreme Court, how important it is can't be overstated or understated. I don't remember, but it's fine. The idea here is that their job in general is to make sure that every constitutional right is protected, which is why a lot of the times you see things like abortion rights are protected by the Supreme Court. LGBT rights are currently being protected by the Supreme Court, and that includes Second Amendment rights. Your gun rights are protected there, along with your First Amendment rights. So a lot of things are determined by the Supreme Court in general. Now, that's a pretty big deal when you think about it, because the essential idea is how the Supreme Court decides how they view your constitutional rights is really determinative of how those things are protected. Now, that's important with cyber law, because a lot of what we're going to be talking about is how has the internet, how is the computers, how has our general electronic culture changed the way that things operate? It's a very complex question. It's a lot of detailed information, right? But the idea in general here is that we want to make sure that you have those constitutional rights, but they're interpreted correctly. For example, if you go to the first part of that handout, you'll see a United States Constitutional Amendment and the Delaware Constitutional Amendment that both deal with searches and seizures. Now, if you didn't know that Delaware had their own constitution, I think that's actually kind of normal. I don't know that I knew that before I went to law school, sadly enough. But the idea is that these are broad provisions that are written in somewhat legal language, right? But they say things like the right of people to be secure in their persons, houses, papers, effects against unreasonable searches and seizures shall not be violated, right? So what does that mean before, and what does it mean now? Now, that becomes an interesting question in regard to certain theories of law. Now, usually there are a lot of other theories of law that you can discuss, but these I think are the most important for this class, meaning you've got two big ways that courts review things. Under an originalist perspective, the Constitution shall be viewed narrowly in view of the original founders, or an evolutionary perspective, where judges look to seek the underlying purpose of the Constitution as it applies to today's world. Now, think about the Fourth Amendment for a second. In 1776, you can imagine what the founding fathers believed that to mean, meaning I can't search your house, because generally the only thing we owned was houses. We didn't have cars, we didn't have cell phones, we didn't have computers, right? Now, a lot of judges who subscribe to an originalist point of view think that the Fourth Amendment only protects your house, that everything else you have, your car, your property, your wallet, your whatever, your bank accounts, your emails, aren't given the same level of protection. They can be given some protection, but they're not given constitutional protection. So when you look at an originalist perspective, a lot of people think it to be somewhat obscure, this idea of, well, why would we view the world the way we viewed it in 1776? But a more practical way to look at it is it's just a limiting perspective, meaning we're not extending the Constitution out toward things that we don't want to extend it to, right? Now, an evolutionary approach takes a much broader view. They look at things and they say, well, hey, again, my old question about your house or your cell phone, where would you want me to be? The idea there is that if people have more privacy rights or expectations in their phone, then that phone should get the same level of privacy and privacy expectations, right? Now, the problem with that is it's very broad and it's almost unlimited in the scope of what you're able to do. Again, the Supreme Court is 9 justices who my guess is many of you do not know. So the idea that the Supreme Court would be all of a sudden be deciding all these rules and all these regulations and all these things doesn't feel right to a lot of people. Like, let's leave that to the legislature. So the idea is that the originalist perspective, limiting, but not a lot of protection, but it's predictable. Whereas the evolutionary approach, it's more flexible, but to what end, right? Because a lot of the ways, if you are a police officer, maybe you don't want people to have Fourth Amendment rights in their cell phone because that's maybe how they're breaking the law all the time. So in general, when you look at this again, the Constitution in general is an idea where it's very limiting in some perspective, but it can also be broad. And it's also mostly broad in regard to its language, meaning that it's written to be interpreted by other versions. Now, the other things I want to note here is that in addition to the Constitution, you also have statutes. Now, statutes can be state or federal, and they cannot contradict the Constitution. So by and large, a statute has to be a predictive rule in the future. Now, if you see the section 6 del C 1201, it's page 2, of the handout you have, you'll note here that there's something called definitions, which you can scroll down. You also see 1205C, posting of private policy by operators of commercial online services. And that seems to be it. All right. So the idea here is that these are statutes, that they're legislative rules for the future. Now, the way that statutes normally work is, again, they're broad in scope because they want to be predicted. Now, interpreted, I would say, by courts, right? So when you see these definitions, these are the legislator's best guess about what these words should mean, right? So you look at some of these words, and you look at internet, website, cloud-based service, content. You're looking at conspicuously available. We're going to talk about that in a little bit later. And then below, when we talk about posting of privacy policy, you're looking at what a website has to do in regard to what their privacy policy is, which is why a lot of the times when you go to a website, you'll see things that say, hey, look at our privacy policy, right? Very obvious. So the idea in general here is that statutes are often a little bit broader, right, than cases, but they're a little more specific than statutes. I'm sorry, the Constitution. So the idea in general here is everything kind of works together. It's a trickle-down effect, all right? Now, the last thing I want to cover is the case Everett versus State. And my suggestion for you would be to read this case if you have time, just to learn a little bit about it. Now, in general, when it comes to this, if you've never read a legal decision before, please stick with me, okay? And please pull up Everett versus State and do this, because this is going to make a lot of sense if you follow me. It's going to make no sense if you don't follow me, right? Now, the idea is this. Every legal decision, going back to my previous decision, tells you who won and who lost, and gives you a predictive outcome for the future. Now, in general, the way legal decisions are is they tell you the outcome right up front. The law isn't like a movie where they save the ending last. You always want to know what you're reading before you read it. Otherwise, it doesn't make any sense. So when you see things like case summary, that's right there, outcome. Yes, that is the outcome. That's not a trick question. That is telling you what the answer to one of the points is. But I'll note that who wins is always less important than how they won and why they won. And that's going to be the main thing that we're going to be talking about in class. So by and large, when you start, always read out and find out who won, why they won, what's this case about. When you read the case summary, you're finding out that a defendant's been arrested, that essentially the police made a fake friend account and asked to be followed on Facebook. He accepted the friend account. The police got a bunch of evidence and arrested him. I know, right? Unfortunate. Hopefully that doesn't happen to anybody here. But the idea in general here is that he's arguing that's a violation of his Fourth Amendment. The Fourth Amendment saying you have a right against unreasonable searches and seizures. Now, we're going to get into this later in whatever way we have to get into it. But the general idea here is that he's making an argument from an evolutionary perspective that his Facebook page should be given Fourth Amendment protection. Now that to me, I think brings up a lot of the balance here. An originalist point of view would say, absolutely not. There's definitely not happening because there's no way the founding fathers would have considered a social networking site. They could even go even deeper. You don't have privacy in things you share with people automatically. But an evolutionary approach might take something differently. They might say something to the extent of, well, you know, if you expect things to be private and you don't want the police to show up, maybe you should get some protection. Now, unfortunately for Mr. Everett, he loses. So the originalist approach wins here. But the main thing I want to note here is that you're going to see these LexisNexis head notes underneath of these. Now, what LexisNexis head notes are from a practical lawyer perspective is they organize the main points in the law for lawyers. They organize all the decisions in a way you absolutely don't have to worry about right now. The benefit for you is they summarize the main points of law so that you can understand what are the legal decisions in the future, right? That seems good. Seems easy, right? So the idea here as we're working through all these is when you read some of these and you go to head note 4, 5, 6, 7, 8, 9, 10, right? These are the most important head notes. And for cases for this class, I'm going to highlight those head notes so that you know which ones to draw your attention to. By and large, they should give you an answer. So you only really need to know what do those sentences mean in general. For example, let's go head note 10. The Fourth Amendment does not protect a wrongdoer's misplaced belief that a person to blah, blah, blah. Hold on, wait, I got this a little off. There we go. I'm still working out the kinks just like probably everybody is, right? A Fourth Amendment does not protect a wrongdoer's misplaced belief that a person whom he voluntarily confines his wrongdoing will not reveal it. If one allows others to have access to his information that contains evidence of criminal wrongdoing, then that person assumes the risk they might expose that information to law enforcement or they might be undercover officers themselves. I think those two sentences, although written in kind of a wonky way, make sense, right? That if you're going to expose your criminal wrongdoings to people, you kind of run the risk that those people might be police. For example, at the end of this video, I'm like, hey, by the way, if anyone wants to sell drugs, I'm willing to buy them, which I'm not doing, right? I'm not doing those. But if I just send them to just this class, I don't have a privacy right in this video because I'm posting it to YouTube and I'm giving it to you. So the idea is that like I don't have a privacy right in everything I think is going to be private. Because one of you might share it with law enforcement, which again, I don't want to do that, or one of you might be law enforcement. So the essential idea here is I just want you to read these ideas, see how they make sense. The other part I want to note when you read these decisions is you're going to see things like factual background. If you scroll down, you'll probably see scope and standard of review and then analysis. By and large, what I'd like you to do is this. Read the outcome, read the head notes, read the facts, right? Don't write any of your homework until you've at least done that, right? That's not too much to ask, I don't think. But the general idea is I want you to get an idea of like, what are the rules? How do the rules apply to this case? I don't need a long dissertation about what happened in the case because that stuff isn't really all that important to me. What's important to me is where you get to analysis on page 12 and they start talking about how the rules apply. Now, you can summarize them. I want them written in your own words. I don't want anything cut and pasted. But the main thing I'm going to note here is that all of the head notes from above are just explained with greater detail in the decision. So kind of if you don't understand something here, it's not the end of the world if you understand the head note. The other point I'm going to note about reading the cases is that you can really get a good idea of what's going on by just reading the topic sentences. I know that sounds weird, but if you read the first sentence in every paragraph, things kind of make a lot more sense than you might think. So if you're confused, do that. If you're still confused and nothing makes sense, just do your best. Honestly, I don't expect that anyone are great legal scholars at this point, but I just want to see your understanding of the material, and I will absolutely simplify everything with future lectures, either via online or via Zoom, that I hope are going to make a lot of sense. So I'm going to tidy up this here now, and I'm going to go into another video that's going to introduce the civil justice system and explain your homework perfectly, hopefully perfectly. We'll see how it goes from there. All right, I'll see you guys in a second.